Our host, Dean Rougeau, is a magna cum laude graduate of Brown University and a graduate of Harvard Law School, where he was the editor of the Harvard Human Rights Journal. Before accepting the deanship at Boston College Law School in 2011, he served on the Notre Dame Law School faculty, and before that, he practiced law with the firm of Morrison and Forrester. Dean Rougeau is the author of the book, Christians in the American Empire, Faith and Citizenship in the New World Order. His scholarship encompasses topics such as Catholic social thought, the role of religion in public life, and the relationship between religious pluralism and understandings of citizenship in diverse urban communities. He's a public leader and a commentator on the challenges and opportunities facing legal education and the legal profession generally. And to a large group of lucky 2Ls, he's your contracts professor. And now, our honored guest, Supreme Court Justice Elena Kagan. Elena Kagan was born and raised in New York City in Manhattan's Upper West Side. Her mother was a teacher, her father was a lawyer. She followed in their footsteps and honored them greatly by rising to the pinnacle, both of those professions. She graduated summa cum laude from Princeton with a degree in history, and then she earned a master's degree in philosophy from Oxford. She graduated magna cum laude from Harvard Law School and was the supervising editor of the Harvard Law Review. She then clerked for former Congressman, but then Judge, Abner Mikva of the United States Court of Appeals for the District of Columbia Circuit, and then, of course, famously, for Justice Thurgood Marshall of the Supreme Court of the United States. After private practice with the Washington, D.C. law firm of Williams & Connolly, Justice Kagan joined the faculty of the University of Chicago Law School. 5 years later, she left her tenured position there to serve in the Clinton White House, first as associate counsel to the president and then as deputy assistant to the president for domestic policy. In 2001, she returned to Harvard Law School, where she still teaches, by the way, published articles in administrative law, presidential power, and on the First Amendment. And in 2003, she became the dean of the Harvard Law School, the first woman to serve in that role. Her deanship is widely famous for her ability to bridge ideological divides, for improving the academic and clinical offerings to students, and generally greatly improving the quality of everyone's life there. She was a leader among law school deans in standing up against the law requiring military recruiters to discriminate based on sexual orientation. In 2009, President Obama nominated her the Solicitor General of the United States, another first for a woman in our country. And that's the same position that Thurgood Marshall held before his historic nomination to the Supreme Court. The following year, the president nominated her, and she was confirmed as Associate Justice of the Supreme Court, only the fourth woman in history to hold that position. And there is one more important historic first that you will not read on the website of the Supreme Court or in Wikipedia, but it is a testament both to her leadership and, in fact, to her athleticism. As you may know, if you have toured the Supreme Court, the top floor of that marbled building, inscribed with the aspiration, equal justice under law, and above the historic courtroom, where many of the most important issues of our day have been decided, is a full basketball court, known appropriately as the highest court in the land. And there is a tradition of justices and their clerks shooting hoops up there. Most famously, perhaps, Justice Byron White, himself a former pro football player. That, however, was an all-male tradition until the late summer of 1987, when Justice Kagan and a small group of her fellow female clerks integrated it, so to speak. Kagan, I will say, was a very speedy point guard with a very effective three-point shot. I was there. It was my good fortune to be that year one of Justice O'Connor's clerks, and so I had the opportunity to get to know Elena Kagan and to call her my friend. That is a slight digression, but not really, because the things that I'm going to tell you now about her are the exact same things I thought about her and everyone said about her way back then. These are things about Elena Kagan that have always been true and have not changed. First, her boss, Thurgood Marshall, He had a reputation of giving his clerks kind of affectionate nicknames. Most of them were just called Knucklehead. Justice Kagan had a special nickname just for her, Shorty. However, despite that nickname, Elena Kagan is an intellectual giant. She can explain the most complicated concepts in the most simple, straightforward terms so that everybody can understand them. For all of her elite accomplishments, she is one of the most down-to-earth people that you would ever meet. She can hang with anybody, and her warmth and good humor makes everybody comfortable with her, and I know that you'll see that today. She can be pretty funny. I mean, how many justices have Spider-Man puns in their opinions, Tommy Two-Tone lyrics, and a quote from one fish, two fish, red fish, blue fish? But that said, she is always respectful of other people and of their feelings. And she always understands and never loses sight of the law's impact on actual people. And finally, in all of my years as a lawyer and all of my years as a law professor to this day, I have still not met another person so genuinely interested in what other people think and why they think it, and so open to considering other people's points of view as informing her own. So please join me in welcoming my friend, Supreme Court Justice Elena Kagan.
Wow, what an incredible introduction. So thank you. I'm introduced a lot these days, and that's the best introduction that I can remember. So thank you. I was wondering when you were going to say that we, get past the resume stuff and say that we actually knew each other, which we did. We were co-clerks together in this year of the OT 87 term, right? I'll tell you a sort of funny story to start. I think it's a funny story. Is Sharon clerked for Justice O'Connor, as she said. I clerked for Justice Marshall. It's kind of hilarious, Sharon Beckman calling me an athlete, because of course Sharon Beckman was this just world-class long-distance swimmer, an incredible athlete. And we get to the court, and Justice O'Connor used to have this exercise class. And it was an exercise class for women of a certain age, shall we say, which I'm getting pretty close to that age. So I can tell you that you don't do the same things in these kinds of classes as maybe 28-year-olds do. And she insisted that her clerks come to this exercise class. So there was Sharon Beckman, who was like swimming miles a day, day after day, sort of going to Justice O'Connor's exercise class and doing, a few jumping jacks or something. But I didn't go, and all the other women clerks, it was only a women's thing, all the other women clerks were invited, and Justice O'Connor really liked them to go, but I didn't. And so, but I did play basketball, as Professor Beckman said. So one day I was playing basketball, and we do have this court up at the Supreme Court, and what you have to know about this court is it's very dangerous up there. It's like a concrete floor. So everybody gets injured all the time. It's actually being fixed this year. It's remarkable. For decades, just like every clerk just goes down to injury. So it was my turn, and this happened to me, and I tore something or other. And I was walking around in crutches for a couple of weeks. And one day I was walking in the halls of the Supreme Court, and Justice O'Connor, Sharon's boss, was walking the other way, and I was, on crutches. And she stopped, and she looked at me, and she said, "What happened?" And I said, "Oh, I tore something or other, while I was playing basketball." And she looked at me very sadly, and she kind of shook her head, and she said, "It wouldn't have happened in exercise." So, and she was probably right about that. So there you are.
Well, thank you so much, Professor Beckman. That was a beautiful introduction, and thank you, Justice Kagan, for being here. Before we begin, I also want to extend some thanks to the Clough Center for the Study of Constitutional Democracy, who's our co-sponsor today. And it happens that the benefactors of that center are here with us today, Gloria and Chuck Clough. So thank you very much for joining us. So what we did to get this event together was that we gathered questions from around the community. So I'm just going to begin, and we'll get started. So when 2 years ago, Justice Sandra Day O'Connor spoke here, and she recounted how difficult it was for her as a woman to find a job in a law firm in the 1950s, despite her stellar academic performance at Stanford. Can you compare her experience with your own early career experiences more than 30 years later?
Yeah, night and day. I mean, the world changed in those 30 years, right? And the Supreme Court, it's interesting this way, as Professor Beckman said, 4 women now, but really 2 in one generation and 2 in another. Justice O'Connor and Justice Ginsburg, and both their stories are remarkably similar. They come out, they've been the stars of their law schools, and they can't get a job. Nobody's hiring them, not as a clerk, not in a law firm. And these 2 quite miraculous women sort of figure out ways to cobble together a legal career in just unusual and unorthodox ways, and nonetheless get to the pinnacle, right? But by the time Justice Sotomayor and I come along, I graduated from law school in 1986. She a few years earlier. It was just incredibly different. 40% of my law school class was women. Law firms were very eager to have us, same for judges and clerking opportunities. You could do all the same things. You could go through so it was really like night and day. And I often look at Justice O'Connor and Justice Ginsburg and think, part of the reason it was so easy for people in my generation was because of all the grief that they went through. And in Justice Ginsburg's case, because of all the work she did in actually developing women's rights in American law. So I think everybody owes those 2 women and other women in their generation who sort of forged the path just an enormous debt of gratitude. I mean, all of us, I think, have experienced at one point or another treatment that you think might not have, might be worse than that accorded a man. But I have to say, for me, it's been pretty few and far between, and not so difficult to cope with. For the most part, I view myself as very lucky in this profession. Again, doesn't mean that the profession doesn't have some structural challenges. I mean, I think actually if you look at the years since me, not the years between me and Justice O'Connor, but the years afterwards, I think actually people thought that women would make even greater strides than they did, in terms of if you look at, partners in law firms or CEOs of companies who have law degrees or things like that. And I think, there are still issues with work-life balance, with making sure that women can have the family opportunities they want and the career opportunities they want at the same time. And those issues, I think, still affect women differently than they do men, and I think we have to work on that as a society. But honestly, I mean, sort of talking with Justice O'Connor and Justice Ginsburg is always, for me, a reminder of how easy I had it, and a reminder for me to be grateful.
Yeah. Well, sort of on the same theme of diversity. When you look at the Supreme Court today, you see that it consists of justices representing a very select group of elite law schools. And of course, the court has historically been dominated by white men. In addition, most of the members of today's court were raised on the East Coast or the West Coast, and interestingly, many of them in the metropolitan New York City area. So what are your thoughts about diversity on the court, not only diversity in the ways we often traditionally think about it, sexual orientation, women, men, race, etc. But in terms of geography and geographic diversity, representing different parts of the country.
Yeah, I think all of this is important. I mean, my basic view about diversity on the court is it doesn't much affect the decision-making we do. It doesn't, when people say, how does it matter that you're a woman inside the conference room in terms of how you vote, in terms of how you decide cases, every once in a while, there's a case in which you can see divides based on personal experience or background, but I have to say it's really rare, and I'm glad that it's really rare. But I do think diversity is important because of the picture that the court presents to the world, and often I sit up on the bench and I look out into the audience and you see a lot of school groups come to the court. And I think, how great it is that all these kids are looking at this court and there are 3 women on it and there's an African American and there's a Latina. And so on some dimensions we do very well, and I think importantly so, because it gives people a sense that the court, which is an important institution of our government, is connected to them in some way. And maybe it would be a better world if that didn't matter to anybody. But that's not the world we live in, and it does matter to people that they can look up there and say, oh, there are 3 women up there, and I can see them and I can hear them, and that inspires me to do something special with my life. And I think that that's a wonderful thing. But it's something that, as you say, there are other areas in which we don't do so well. The geographic area, that's obviously the case. We're an extremely coastal court. The Chief Justice, Justice Thomas, grew up not on the coasts, but I think that they're the only 2. As you say, there are 4 of us from New York City alone. And we are, if you look at the court now, it basically comes from 3 law schools, mostly Harvard and Yale, and then Justice Ginsburg spent a couple of years at Columbia. And, that's sort of, in a way, ridiculous. I mean, there are lots of great lawyers all over with all kinds of degrees, and it's a little bit just more fluky than anything else. And so, I think that those are things to change in the best of all possible worlds. You can see how you can't have everything just because these nominations come up kind of one at a time and rarely for any president. And each president has their own list of priorities, and just sort of through random chance, it might happen that it's just like not the thing that's first on anybody's list as to what the geographical composition of the court is when they're filling maybe the one appointment that they're going to have in a presidential administration. So I think it's unfortunately just sort of happened that way, that it seems quite sort of coastal and law school elite, and it'd be a better thing if not. I'll tell you another story that I think is kind of funny. When you're nominated, you go through this set of courtesy interviews with all these senators. And my first, it follows this very hierarchical pattern that you first have to meet with the majority leader and the minority leader, and then basically by seniority and things like that. So my first interview was with Harry Reid, who was then the majority leader of the Senate. And I walked in, and he said, it's really good to meet you, Ms. Kagan, and I've heard a lot about you. I told the president that I wanted 2 things in a Supreme Court nominee, and he said, and you're one of them. And I thought, I hope that's the important one. I said, well, what were the 2 things? And he said, the first thing I said to the president was, we can't have another person who is coming out of an appellate court, which I didn't. I'm the only one of the 9 of us who was not previously a Court of Appeals judge. So I said, okay, I got that one down. Many people are going to view that as a weakness, but I'm glad to know that you think it's a good thing. And And then he said, and the other thing I told the president was we cannot have another justice from Harvard or Yale. And I'm thinking, I'm like the dean of Harvard Law School. I just don't have like a degree. So anyway, he got over it. But
Well, actually, you anticipated one of my next questions, and that's your background in terms of not being from the bench. How does that affect your take on the role that you're playing on the court?
yeah, I'm not sure it does much. I think the first year for me was, I had to deal with some issues that my colleagues did not have to deal with. I had to learn how to be a judge at the same time that I was learning how to be a Supreme Court justice. And there were just sort of mechanical things about what that meant. Was I going to, how do you write these opinions? And how do you use clerks? And, just what were the processes for thinking through a case? How do I best learn a case? Do I talk to one clerk? Do I talk to all of my clerks? When do I talk to them? When do I read the briefs that will be most useful to me? What do I ask my clerks to do? I think being a clerk for me, my first year, was I think probably very exciting, but also very frustrating, because I was just making it up as I went along, and I would ask my clerks to do these things, and they would carry out exactly what I had asked them to do. And I would look at it and I would say, well, that's just a waste of time for, let's never do that again, So I think my colleagues, they had this all, just the work process figured out, and I had to figure it out on the job, so to speak. But honestly, that only took a year or so, and then I sort of figured out how I learned and how I did the job best, or not that every year I learn more and more, but just sort of the basic mechanics of the thing. I think I had sort of pretty much, figured out over the first year how I best worked. But I don't think, I guess, I guess there were some areas of law which were very new to me. Mm-hmm. Fewer because I had been Solicitor General for the previous year, so that's as good a substantive preparation for the court as I think you're going to get. Maybe I had to do a little bit more learning on the job than my colleagues did, but I doubt that it much affects now the way we think about cases or do law or do the job.
Well, speaking of writing opinions and clerks, you've had a lot to say about writing as an essential part of the lawyer's craft, and you've asked law schools to, think deeply about how they teach writing to their students. And I wonder if you might talk to us a little bit about what you think distinguishes good writing and what we could be doing in law schools to help improve the quality of writing.
Yeah, I wish I had the prescription for it. I said this just recently in an interview I did with a sort of master of legal writing named Brian Garner, and I was surprised to see how much press it got. But I was glad to see how much press it got too, because I do think that this is really important. And sometimes law students come in, and I don't know exactly how it works here, but at Harvard, which is the school I know best, I think sometimes law students come in and they think of legal writing as like not quite the important stuff, They're going to learn contracts and they're going to learn torts, the big substantive, and legal writing maybe gets short shrift. And I think that's exactly wrong. The 30 years down the road, what you learned in your torts class is just not going to matter all that much to you. But whether you learned to do excellent legal writing is going to matter a ton. There are some lawyers who have world-class careers without having to write a lot. But I think for the most part that's not true. To be a world-class lawyer, you have to do a lot of writing and you have to be good at it. And it's hard. Good writing is hard generally, and then good legal writing is harder than that, because a lot of legal concepts are complicated and arcane and not particularly intuitive to an audience. And figuring out how to convey these complicated arcane ideas in in a way that people can understand and in a way that sticks with people is something that, I think every day I wish I could do better. So, I think that, law schools have got to figure out a way to convey to their students the importance of this in a legal career. And then I think law schools do, and it's hard. It's the hardest thing to teach is writing.
Right.
It's a whole lot easier to teach a substantive area of law than to teach that skill. But I do think law schools generally just have to do more thinking and pay a lot of attention to it.
Now, you've been praised really for the clarity and readability of your opinions, and actually a little bit beyond that, you've really kind of pushed the envelope a little bit in terms of toning down, I think, some of the high formality of some of those opinions. How do you make a judgment in your position as to whether or not it's time to maybe get things done a little bit differently in that kind
Yeah. I mean, I try very hard to make them readable and to make them accessible. I sort of think if I weren't a lawyer, if I didn't have a law degree, could I understand what this opinion is about? And you don't want to dumb things down, and you don't want to glide over the complexity of a subject. But to the extent I can, I really do try to make them read in a way that non-lawyers could understand. And then, as you say, I am a little bit colloquial in the way I write, even more so in my separate opinions, in my concurring and dissenting opinions, than I am in my majorities. And in my majorities, I feel a kind of obligation that I'm writing for the institution, that I'm not only writing for myself. So I strike a different balance in those cases for exactly the reason that you said, that it seems maybe when you're writing for the institution that you should adopt a tone that all members of the court are comfortable with and that people will see as, not so everyday. But even there, I suspect I go further than my colleagues in using colloquialisms and in using sort of down-to-earth language, or even in kind of making jokes, puns and citing Superman and Spider-Man and comics and things like that. And I don't know, I figure there's some that gets left on the cutting room floor. There's some, both in my chambers. I always tell my clerks, like, don't be an enabler, Quite the opposite, like tell me when I'm going too far. And they do, and I'm grateful for that. And then, when I circulate opinions, sometimes my colleagues will say, yeah, I don't really like this, could you take it out? And I always do. So I figure what's left, they must be okay with. They're not shy. And I don't know, so, partly it's, I guess I don't want to cut back too much because I actually do think that, to the extent that people find reading about law sort of interesting and engaging and even occasionally amusing, that's a good thing. Where, sometimes I go back and I read some old opinions and they're so like in another language. They're so, lawyers speak. And I guess I really do have an allergy to that. And to the extent that you can convey that this law stuff, it's really serious, but it's also not the special province of a special elite group of people. It's actually something that we can all participate in. I think that's a good thing.
That's great. Well, we were talking a little bit about the lawyer's craft. Another aspect of it, obviously, is oral advocacy. And I wonder if you might have some thoughts and comments on the kind of oral advocacy you're seeing in the court. Are you impressed with it? Where does it fall short? What are the oral advocates like before you?
We have great, great, great advocates. I mean, I think all of us, anyway, me, I feel lucky every day when I enter into the courtroom. We have a pretty specialized Supreme Court bar now. We hear from a lot of people who have a lot of experience in this. So, and And I think that that's a good thing. I think the more you do it, the better you get, and the more you understand us and understand how to make arguments to us. And for the most part, the lawyers we hear from are really skilled, really sharp, really terrific lawyers, and they serve their clients well, and in doing so, they serve the court well. So it's a fantastically hard thing to do, to argue to the court. I mean, there they are. There are 9 of us. They only have a half hour, and we have a ton of questions, and the questions are coming at you from all sides, and they're just coming fast and furious, and really. We're giving people 2 or 3 sentences to answer them before somebody else asks another question. Occasionally, they'll get some longer stretches of time to really lay out an argument. But in an important case, I mean, you just have to just think that you're just, I would bet in a 30-minute argument you can get 60 questions easily.
Wow.
Yeah, and so you have to, you have to prepare incredibly hard. You have to really think through every question you could possibly get and think about how you're going to answer it and think about how you're going to answer it quickly. You have to think through the questions so that you can know, here are the 2 sentences that are the most important 2 or 3 sentences to say, because I might only get 2 or 3 sentences. So, it's not something everybody can do. I found it when I was Solicitor General. I mean, it was hard. People sometimes say, do you prefer being on that side of the podium or on this side of the podium? And I'll tell you, it's a lot harder down there talking to the court than it is asking lawyers questions. And I have just incredible respect for the people who appear before us and who do it well. But it's a sort of special skill because it requires great speed. Some people are sort of more deep, slow thinkers, and some people are just quicker on their feet. This is a quick on your feet kind of skill, and but it also requires just incredible amounts of preparation, which I think all the people who do it really super well, that they'll say that the number one secret is to work really hard.
Yeah. Well, since we're really talking about professional skill, what advice would you offer law students as they're sort of beginning to launch their careers in terms of what you've seen in the various environments in which you've worked? What's really essential for a young lawyer to have when he or she leaves law school?
Well, I'm not sure I have anything very original to say about this. I mean, I think you should find something you're really deeply engaged by. Too often I think law students don't think quite hard enough about what really makes them happy and the work that really is most meaningful to them. So there's a little bit of like just everybody else is doing X, so I'll do X. So I think using law school as an opportunity to find out what your real interests are, what your real passions are, is an important thing. And then going with them, notwithstanding that maybe they're different from other people's. In terms of succeeding, I mean, I think the keys to success are to work hard and to treat people well, and that doesn't sound very. It's like, well, duh, but both of those things I think are really important. Working hard and sticking at things and showing determination. And on the other hand, just the kind of face that you present to the world, to your colleagues, to your clients, to, I think it behooves people not to be always, not everybody treats well the people on top of them in a hierarchy, but maybe where people fall off the train a little bit is treating the people who are lower than them in these various hierarchies that we live in, the same way as you treat your peers and as you treat your bosses, and I think you should do that because it's a good thing to do, but it also just in all kinds of ways I think people who treat people well, sort of unexpected benefits come to them down the road.
Yeah, right. I'm going to shift things a little bit. where does someone who grew up on the Upper West Side of Manhattan learn how to shoot a gun and go duck hunting? I'd like you to tell us a little bit about your duck hunting experience with Justice Scalia.
Yeah, so this actually, the answer is someone who grows up in Manhattan does not learn from that how to shoot a gun. But so when I went through the confirmation process, as I said, you do these courtesy visits. I did visits with 82 senators, and it's funny when you say to people, like, what's the subject that they most asked you about? Like, everybody thinks, oh, they most ask you about abortion or religion things, and it turns out that what everybody, at least for me, at the time I was going through the hearings and maybe given my background a little bit, what everybody wanted to know about was my views on gun issues, on the Second Amendment issues. But nobody can just ask you things like that. Nobody can say, tell me everything that you think about the Second Amendment and tell me about what you think of this case and that case. So they have to find sort of proxy ways to figure out. So I just had more conversations with senators where I would sit down and they would say, have you ever hunted? and I would say no, and do you know anybody? Does anybody in your family hunt? And I would say no. Do any of your friends hunt? And I would say no, And, have you ever, touched a gun? And I would say no. And this was all going very poorly, really. And it was coming from, Republicans, from Democrats, from every which way. And so one day I'm sitting with one of the senators from Idaho. And he starts down this road, and he was telling me that he had a ranch and the hunting that he did in his ranch, and the importance of this in his life and in many of his constituents' life, and the importance of gun culture, and a sort of expressing suspicion that this woman from New York who was sitting next to him could ever really understand this. And I said, Senator, you're exactly right that I've really not had an opportunity to participate in this kind of these activities. But I said it's not like I'm hostile to them. In fact, if you were to invite me hunting next week on your ranch, I would love to go. And this look of abject horror, came across his face, and the White House staffer, there's always a White House staffer in the room who sits with you. The White House staffer she looked like she was just going to drop off the end of the sofa. And so I thought I probably went too far there. So I said, Senator, I didn't really mean to invite myself to your ranch. But I said, I'll make you a promise that if I'm lucky enough to be confirmed, I will ask Justice Scalia, whom I knew to be a quite avid hunter, to take me hunting. So I was lucky enough to be confirmed, and that summer I went to Justice Scalia, and I told him this whole story, and he thought it was uproarious, and he said, "We're on it. We're doing." And I said to him, "This is like the only promise I made in 82 visits." So. Said, we're on it, and he took me, he's a member of a gun club in Virginia. He took me there, and we shot clay pigeons for a while, and I learned how to shoot some. And then he has a bunch of guys that he goes bird shooting with, and we did that a few times, and I really quite liked it. I really quite enjoyed it. It's good exercise. You tramp around these fields. It's like, I'm kind of a competitive, goal-oriented person. So it's like you put a gun in my hand and you give me, the object is to shoot birds out of the sky. I'm like, okay. So I had fun. After a year, he said to me, it's time for big game. And so we went down to Wyoming together with a deer license and an antelope license. Wow. And we didn't find any antelope. We each shot a deer. But I told him at the end that I didn't like that so much. It was not very, you just sit there in this blind and just sort of wait for the deer to come. And I found it, you can't even talk, So I found it, I have to say, a little bit boring. So I said, let's keep on going with the birds, but let's forget about this deer stuff. But then he had another challenge. He said we were going to go duck hunting, and we did that last year. We went duck hunting down in Mississippi together, which was, I thought was extremely beautiful, actually. You're in the midst of these woods as the sun comes up. It's quite an experience, actually. And you wear these big like waders things, and you're basically just standing in the water, and it's so I very much enjoyed that. So we might go duck hunting again.
Sounds good.
But quail, I'm on the quail.
All right. Great. Well, Justice Kagan has graciously agreed to take questions from the audience. So we're going to use the rest of our time for questions from members of the audience. I think I have some folks who will be appearing with microphones momentarily. And please feel free to ask a question.
Justice Kagan, forgive me for starting with a bit of a downer, but what's the biggest frustration of being a justice on the court?
Well, for the most part, it's a good gig. So I guess it's easier to talk about all the great things about the job than about the frustrations. I don't know. The greatest frustration, I guess, is when there are important cases that you care about a lot and they don't go your way. And that's the greatest frustration. And it's going to happen. It's going to happen every year. And so you have to learn how to, recognize that as, not to stop caring about it. Yeah, they put us in this job to care about the issues that come before us. But you have to learn how to, put it aside and think about the next case and the next one after that. But I guess that's the greatest frustration. Sometimes I come back to my office after conference thrilled, and sometimes I come back to my office after conference disconsolate. But it's part of the job for all of us. It's a 9-member court. You're not going to get your way all the time. And so you have to keep caring, but understand that too.
Right. Yep.
So first, Justice Kagan, thank you so much for coming here. It's been an honor to hear you speak. So I have a question written. Given the recent incidents of documented police brutality across the United States, is there a role the judiciary can play in its review of 42 U.S.C. 1983 actions to deter local and state actors from using excessive force?
Well, what I do in my job, what we all do, is to decide concrete cases. We don't opine just on big issues, and we don't put out position papers on everything police forces ought to be doing. And this is a critically important issue in our society right now, and one on which many people will engage in all kinds of ways. And I'm sure that in law schools, people are thinking hard about this issue, as they are in the world. But the only way that I can think about this issue or do anything with respect to this issue is by seeing how it appears in cases that come before me. And sometimes it will. There will be cases that will involve police stops of various kinds, police activities of various kinds, and will be required to set the rules for what ought to happen. There will be 1983 suits, and we'll be required to set the rules of those sorts of actions. But that's the way I think about my job. It's not. As a citizen, I pick up newspapers and I have views about issues like this in the same way that everyone in this room does. But as a judge, I can only sort of look at concrete cases and decide what I think the right answer is on those cases.
I think we had a question right here.
Thanks for coming in today, Justice Kagan. My question for you is, what is the biggest issue facing the United States justice system? And I guess to this crowd, how do you think that we could go about fixing that in the up-and-coming generation? Thank you.
Yeah, I mean, I'm honestly going to say a little bit the same thing that I said to the last question. It's just not the way I think about my job, to say that I'm the opiner on big issues of like, here's what's wrong with the American legal justice system, here's what's wrong with criminal justice. I mean, we have an important job, but it's also a confined and constrained job, where we pick 80 cases to argue, and then we decide those cases. And that's my role in the legal system. And you know, if you said to the Attorney General, what's the most important part of the Attorney General better have an answer to that question, right? The Attorney General better have the ability to say to you, here are my 4 priorities in leading the U.S. Department of Justice, right? But I don't have priorities like that as a judge, let alone in thinking about the entire legal system, which, you know, the entire legal system is a bigger thing than just all the cases that are happening in courts. And so, you know, you got to know what hat you're wearing in life. And I think the hat I'm wearing is not one as sort of the opiner on everything about the dispenser of justice in the country. I have a big enough job as it is, and I try to do that well, and I try not to overstep my bounds. I feel like I'm frustrating your students. But
Well, let's see. You're going to have to raise your hands high. We have this question here and a question there. So those, right here. Okay, whichever. They're right by each other. So.
Thank you very much, Justice. What is your goal when you write a dissent where your colleagues are joining you?
well, it's nice when I'm writing a dissent where my colleagues are joining me. If enough of them join me, then it's not a dissent anymore. And that's even nicer, actually. So I guess one goal in some cases, not in every case, occasionally you start writing a dissent and you think maybe I can flip a vote. And that's a goal, is how do I flip a vote to make this dissent into a majority? Doesn't happen often, but occasionally it happens. But I think different dissents have different goals, honestly. And you know, sometimes you might be writing a dissent where it's just, look, we heard this case, I disagree with the majority on it. It's important for me to say so because it's what I think, and it's important for me to, and it's important also because it expresses to the parties and to other interested people that this case is not so easy, that this case actually is hard, that there are, you know, 2 sides to it, and that I think the court got it wrong. But once I'm done writing the dissent, it's like done with. And the next case that presents the same issue, I'll, you know, accept the majority opinion as much as the people who joined it did, and go forward from that, right? And a lot of dissents are just like that. It's like it's part of the job to express why you disagree, why you would have reached a different outcome. But once the dissent is out there and it's published, it is done. You're over with it. But other dissents are more than that. Other dissents are, you know, I'm writing this because I think the law should be this even after this decision. And, you know, I hope that the law comes around to this point of view, and I'm going to try in this dissent and afterward to try to get the court to come around to this point of view, to admit that it made an error. And so you're a little bit, you know, writing for the future and writing as a marker to say how you're going to think about, how you're going to continue to think about an issue in the future. And those are much rarer. You know, in in some sense, they're the dissents where you sit down and when you write them, you think, that you think I'm doing something important. I better do it well. But so I guess there are dissents and then there are dissents. There are dissents like I disagree, but such is life. And there are the dissents. It's like I disagree. This is super important. I'm going to continue to disagree. I'm writing this so that people out there, judges, citizens, know that this is going to be a continuing issue, and I'm hoping to convince them to be on my side of it.
Okay, let's see. Here and then here and there, and we'll. Those are the next three, and we'll see if we still have time.
Hi, this is Kagan. It seems like every year cases come down about the death penalty, and more recently it seems that the drug cocktail solution is just not viable. Do you think there will be a certain point where, because the United States just can't use drugs and it has just become so inhumane, that will be the reason that the death penalty will ultimately have to be reconsidered? Or do you think it's more likely that the court will just keep adopting other methods?
Your students are sort of not getting the message here. And I mean this as an important message. There are going to be lots of cases that are going to come before me in various forms where I'm going to be ruling on the legality of forms of the death penalty, of ways in which the death penalty is administered, and all kinds of other legal issues that come about as a result of capital punishment. And I'll try to do the best I can on those cases, but I'm it's just I don't go to law schools and sort of opine on issues like this. I really just try to look at a concrete case before me and answer it the best I can.
So that we might maximize the benefit of the justice's time, if you have a question, please consider its content in light of what you've just heard thrice. So once again, I'll ask for hands, but as I said, please consider the content of your question in as much as you'd like to get the justice's response, and we use her time to its best advantage. So how about all the way in the back there with the blue? Yeah. Oh, I'm sorry, there was someone who previously called upon.
Hi, Justice Kagan. I want to reiterate our thanks for you being here today. My question is on public opinion. We spent some time in law school discussing the effect of public opinion on the court and whether the court leads public opinion or follows public opinion, and I'm interested in your views on that issue.
Yeah. So I don't think we ever look at public opinion in the way that political actors do. We don't stare at polls. We don't say, do people like gay marriage or not like gay marriage? Do people like Obamacare or not like Obamacare? I think to a person, 9 of us would think that is utterly irrelevant to what we do and to the kinds of decisions we make. Whereas, it's very relevant if you're a political actor, if you're a president, if you're a Congress, you better know what people want, because at least part of your job is to be responsive to people and to think about public opinion when you do things. And I think for us that's just not true, that we don't, the court is not supposed to be a responsive institution in that way, and it's not supposed to look as to what a majority of Americans think about any issue. Part of our role is actually to say, sometimes a majority of Americans want X, and we think the Constitution demands Y, and it's too bad. So in that sense, I think the court really just does not care about public opinion. In a broader, deeper sense, the court lives in a society, and I think it's not it's not surprising that the court in some way reflects the society in which it lives. And so if you look at trends in the law and the way the court makes decisions, it does reflect overall views and perceptions and attitudes among Americans. So, just there are, obvious classic examples of that. Why does Brown v. Board get decided the way it does in 1954 and not decades earlier? Why does the court discover in the 1970s women's rights in a way that just hadn't been done decades earlier? Partly these things are that the court is reflective of the society in which it lives and of the broad attitudes and of a society, and that shouldn't be surprising and is not disturbing. Sort of the opposite. If the court were like, the lone holdout, that would create the bigger issues, I think. But in the kind of like, are we looking, at what today's Americans think on some particular issue? I just don't think it happens that way.
No, yeah,
Hi, Justice Kagan. Thank you for being here today. So in June, I had the opportunity to see Justice Ginsburg speak, and she said some of her role models growing up were Nancy Drew and Amelia Earhart. So I just wanted to ask you who are and were your role models.
Boy, Nancy Drew seems to be a common one for the court's women's, because I think Justice Sotomayor has a Nancy Drew thing too, and I think, I'm not sure. I read some Nancy Drew growing up too, although I'm not sure, I don't know, a role model? I don't know. Amelia Earhart, that's a great one. Or now I have to think about role models, I don't know. Who were my role models? I don't know. Honestly, like as a kid, it was too long ago. I mean, I realized for Justice Ginsburg it was even longer, and I'm feeling really deficient that I can't come up with these. I was really lucky when I was a young lawyer to clerk for two people who I thought of as great role models, Ab Mikva and Thurgood Marshall. And, I don't think of myself as necessarily the kind of judges that they were. I think we all have to be our own judges. So I don't try at all, really, to replicate what they did. Not that I could anyway, but those couple of years in my life, which were very formative in my legal career, to see how these two men had pursued the advancement of justice in their own legal careers, was extraordinarily important to me. And just to say a few words, especially about Justice Marshall. I clerked for him at a time it was one of his last years on the court. He was a little bit looking back on his life, and we had this really, really rich, extraordinary experience of listening to him as he reflected on the life that he had led and all the work that he had done. And I look back on that year, and I think I guess it was the most extraordinary year of my life to have that happen to me, to just have been in the room when this iconic person in American law, I think the greatest lawyer of the 20th century, reflected on everything that he had been through and what he had accomplished. And so I think that more than the Nancy Drew kind of like when I was 8, I think that in terms of my life, that was the year that mattered most, and the person that mattered most in terms of my thinking about what it was to to have a life that you could feel mattered.
I think we have time for one more question. Mike V. Michael V.
Thank you, Dean. Welcome, Justice Kagan. You mentioned some of the superb advocacy that you see every day and the interplay with the justices. Currently, those arguments are archived on audio and are available by audio. Do you envision a day when those arguments would be able to be viewed in real time?
Yeah, I don't know. This is obviously, it's an issue in which lots of people don't really understand why the court does what it does, and I appreciate that. I used to think when I was Solicitor General, and I would sit in addition to the arguments that I myself made, I would always go to the court and listen to the arguments when my colleagues argued, and that meant that I was, there most of the time. And I used to think, what an incredible show this is. And not just a show, I mean, what an incredible demonstration of how one of the institutions of our government works. Because the level of advocacy, I think, is really high. I think that when you sit there in that courtroom, you see that the justices are extremely prepared. I think you see that the justices are really trying to get things right. We have deep disagreements in our society, but when you watch us work as an institution, I think you are brought to a greater appreciation of the fact that we're really trying to understand the cases before us and to get them right. And wouldn't it be a great thing if people could see that, and wouldn't it deepen the appreciation and the respect they have for one of their institutions of government? So on the one hand, I completely understand why people might want this, and actually think myself that it might do some good. On the other hand, I think people are very concerned that it will change the nature of what actually happens in the courtroom. And that would be a bad trade. If because cameras are put in the courtroom, what happens in the courtroom is not so serious. And it's not crazy to think that that might happen. I mean, we all like to think that we're adults and that we don't respond to the fact that there are cameras there. But if you look at the history of Congress and you think about what were congressional hearings like before cameras and what congressional hearings are like now, I have to say that that is not an improvement. People, you like to think that you wouldn't play to the cameras, but I think it's hard to put them out of your mind, and it would, I think, change in subtle ways, and maybe not so subtle ways, the nature of the conversation that we're having with lawyers and the nature of the conversation we're having with each other. In some sense, oral argument is a conversation among the justices prior to conference. It's part of the reason we ask so many questions, and part of the reasons why some of the questions don't really sound like questions. They sound more like points, is because we're talking to each other. And that's an incredibly important part of the decision-making process. And you wouldn't want to do anything that disturbs that process, which I think right now works pretty well. So I think it's just really a hard call, and I think as the years go by, we're going to continue to face questions about this, and maybe to to try to find ways of being more accessible, even if not all the ways that everybody wants. But it's a serious issue.
Well, Justice Kagan, on behalf of the entire Boston College community, thank you so very much for being with us this morning. It's been an honor.
Thank you very much.